Did a federal court just make open carry legal in California? Number. And I want to start there deliberately because the confusion surrounding this decision is exactly why it matters so much. Right now, you're hearing a lot of very confident claims about what just happened. Some people are celebrating, some people are dismissing it, and almost everyone is skipping over the part that actually matters. Because this ruling is not about flipping a switch overnight. It's not about instant legalization, and it's not about one state, one statute, or one narrow issue. It's about whether states are allowed to comply with the Second Amendment in theory while denying it in practice. And for the first time in a very clear way, a federal appeals court just said there are limits to that strategy. To understand why, you have to understand what California has been doing since the Supreme Court's decision in New York State Rifle and Pistol Association versus Bruen. After Bruen, states like California publicly acknowledged that the old may issue licensing schemes were unconstitutional. On paper, they complied. They changed language. They rewrote statutes. They told courts they had adjusted their laws. But in practice, California maintained a framework where public carry, especially open carry, remained effectively prohibited across most populated areas of the state. Not technically everywhere, but everywhere that actually matters. Cities, urban counties, commercial districts, places where people live, work, shop, and travel. So while the state could point to a statute and say the right still existed, the plaintiffs argued that in real life, it didn't. They argued that what California had created was not regulation, but a near-total ban on public carry. And the appeals court agreed with that argument in part. That phrase, in part, is important because the court was careful. This was not a reckless opinion. It was not written for headlines. It was written for courts. The court did not say California has no authority to regulate firearms. It did not say states must allow unrestricted open carry. And it did not say that every carry restriction is unconstitutional. What it said instead was more precise and far more dangerous for states trying to push the limits. Under the Second Amendment, as interpreted by the Supreme Court in Bruen, a state cannot design a regulatory system that eliminates public carry in practice, even if the law technically preserves the right on paper. That's the core holding. Bruen does not require states to choose open carry over concealed carry, or concealed carry over open carry. But it does require that at least one meaningful avenue for public carry actually exist for ordinary law-abiding citizens. And that's where California's framework ran into serious constitutional trouble. The court followed the Bruen framework exactly. There was no shortcut. There was no balancing test. There was no interest weighing. The judges looked at the text of the Second Amendment. They looked at history, they looked at tradition, and they examined laws from the founding era, from the early republic, and from the period surrounding the ratification of the 14th Amendment. And the historical record was consistent. There is historical support for regulating how firearms are carried in public. There is historical support for restricting carry in certain sensitive places. There is historical support for licensing regimes. But there is no historical tradition that supports a system where both open and concealed carry are effectively prohibited across most public spaces. That distinction is not new, but it is now being enforced. Regulation has historical roots. Elimination does not. That line is what California crossed. Now, this is where a lot of people misunderstand what happened next. This ruling did not instantly legalize open carry in California. There was no statewide injunction. There was no immediate change in enforcement, and no law vanished overnight. What the court actually did was invalidate specific provisions that made open carry practically impossible in large portions of the state, and then remand the case for further proceedings consistent with its opinion. That matters because it means this case is still alive. Lower courts still have work to do. State officials still have choices to make, and nothing changes automatically. But something very important did happen. The appeals court drew a constitutional boundary. It told California clearly that it may regulate public carry, but it may not construct a legal framework where the right exists only as an abstract idea and not as a usable reality. Once that principle is stated, it does not stay confined to one statute or one state. It applies to how states define sensitive places. It applies to permit conditions that appear neutral but function as barriers. It applies to layered restrictions that, when combined, make public carry practically impossible. And that's why this ruling has national implications. California is not alone in trying to comply with Bruen on paper while resisting it in practice. Several states responded to Bruen by saying, in effect, fine, the right exists, but only in theory. They preserved carry permits in statute while expanding sensitive places, stacking conditions, and narrowing access until the right became hollow. This ruling directly challenges that approach. It tells courts to stop looking only at statutory language and start examining real-world effect. That's a shift. Now let's slow down and talk about what happens next, because this is where expectations need to be realistic. California has options. The state can seek rehearing. It can attempt to revise its carry laws, or it can return to the lower courts and try to defend the existing framework under the standards the appeals court just laid out. What California cannot do, at least under this ruling, is pretend the problem does not exist. And this case is not happening in isolation. Across the country, courts are struggling with how to apply Bruen. Some courts are reading it narrowly, others are applying it as written. Over time, patterns are starting to emerge. When multiple federal appellate courts begin converging on the same principle, that matters, especially when that principle limits state power in a way that affects millions of people. If several circuits conclude that states cannot practically eliminate public carry, that creates exactly the kind of pressure that draws Supreme Court attention. That does not mean immediate Supreme Court review, but it does mean the issue is not going away. Now let's talk about what this means right now, because this is where misinformation spreads fastest. As of today, California's carry laws remain in effect. Open carry is not suddenly legal statewide. Enforcement has not stopped, and anyone telling you otherwise is overstating the ruling. But legally speaking, the ground has shifted. This decision strengthens future challenges. It narrows the argument states can rely on. And it reinforces Bruen's core command that the Second Amendment protects real, usable rights, not symbolic ones. That distinction matters more than it sounds like it does. Because a right that exists only on paper is not a right in any meaningful sense. It's a permission structure, and the Constitution does not protect permissions. That's the deeper significance of this case. It's not about open carry versus concealed carry. It's about whether courts are willing to look past formal compliance and examine practical reality. In this case, the appeals court said yes. And that answer doesn't produce instant change, and it produces pressure, it produces precedent, and it produces clearer constitutional boundaries. That's how post-Bruen litigation is actually working, not through dramatic overnight reversals, but through incremental corrections that gradually force states to adjust. So no, this ruling does not instantly legalize open carry in California. But yes, it meaningfully weakens the legal foundation of California's public carry restrictions and signals, where courts are increasingly drawing the line. That matters for California. It matters for other restrictive states. And it matters for how the Second Amendment is applied in the real world, because rights that only exist in theory do not survive scrutiny forever. Eventually, courts have to decide whether the Constitution protects something real, or whether it allows governments to hollow rights out while claiming compliance. This ruling moves that answer in a very clear direction.